16 Gerbert Corpuz vs Daisylyn Tirol Santo Tomas and the Solicitor General. GR number 186571. August 11, 2010. Facts. Petitioner, Gerbert Corpuz, is a former Filipino citizen who became a Canadian citizen through naturalization. Subsequently, the petitioner married the respondent, Daisylyn Santo Tomas, a Filipina, in Pasig City. After the wedding, petitioner went back to Canada due to work commitments. However, when he came back he was shocked to discover that the respondent is having an affair with another man. Thus, petitioner went back to Canada and filed a petition for divorce. The Superior Court of Justice, Windsor, Ontario, Canada granted the petitioner's petition for divorce. The divorce decree took effect a month later, January 8, 2006. 2 years later, the petitioner has already moved on and found another woman that he wants to marry. Thus, for his love to his fiancée, the petitioner went to the Pasig Civil Registry Office and registered the Canadian divorce decree on his and the respondent's marriage certificate. Despite the registration of the divorce decree, an official of the National Statistics Office informed the petitioner that the marriage between him and the respondent still subsists under the Philippine law and to be enforceable. The foreign divorce decree must first be judicially recognized by a competent Philippine court, pursuant to NSO Circular No. 4, Series of 1982. Accordingly, the petitioner filed a petition for judicial recognition of foreign divorce and/or declaration of marriage dissolved with the RDC. The RDC denied his petition, hence this recourse by the petitioner. Issue: whether or not the second paragraph of Article 26 of the Family Code extends to aliens the right to petition a court of this jurisdiction for the recognition of a foreign divorce decree. Ruling: no. Even though the trial court is correct in its conclusion that the alien spouse can claim no right under the second paragraph of Article 26 of the Family Code as the substantive right it establishes is in favor of the Filipino spouse due to the given the rationale and intent behind the enactment. And as such the second paragraph of Article 26 of the Family Code limits its applicability for the benefit of the Filipino spouse. However, we qualify the above conclusion made by the trial court because in our jurisdiction, the foreign divorce decree is presumptive evidence of a right that clothes the party with legal interest to petitions for its recognition. Even though, the second paragraph of Article 26 of the Family Code bestows no rights in favor of aliens with the complementary statement that his conclusion is not a sufficient basis to dismiss the petition filed by Corpuz before the RDC. The unavailability of the second paragraph of Article 26 of the Family Code to aliens does not necessarily strip Gerbert of legal interest to petition the RDC for the recognition of his foreign divorce decree. The foreign divorce decree itself, after its authenticity and conformity with the alien's national law have been duly proven according to our rules of evidence, serves as a presumptive evidence of right in favor of Gerbert, pursuant to Section 48. Rule 39 of the Rules of Court, which provides for the effect of foreign judgments. This section states: Section 48. Effect of foreign judgments or final orders. The effect of a judgment or final order of a tribunal of a foreign country, having jurisdiction to render the judgment or final order is as follows. A. In case of a judgment or final order upon a specific thing, the judgment or final order is conclusive upon the title of the thing, and b. In case of a judgment or final order against a person, the judgment or final order is presumptive evidence of a right as between the parties and their successors in interest by a subsequent title. In either case, the judgment or final order may be repelled by evidence of a want of jurisdiction, want of notice to the party, collusion, fraud, or clear mistake of law or fact. To our mind, direct involvement, or being the subject of the foreign judgment is sufficient to clothe the party with the requisite interest to institute an action before our courts for the recognition of the foreign judgment. In a divorce situation, we have declared, no less, that the divorce obtained by an alien abroad may be recognized in the Philippines, provided the divorce is valid according to his or her national law. The starting point in any recognition of a foreign divorce judgment is the acknowledgement that our courts do not take judicial notice of foreign judgments and laws. Justice Herrera explained that, as a rule, no sovereign is bound to give effect within its dominion to a judgment rendered by a tribunal of another country. This means that the foreign judgment and its authenticity must be proven as facts. Under our rules on evidence, together with the alien's applicable national law to show the effect of the judgment on the alien himself or herself, the recognition may be made in an action instituted specifically for the purpose or in another action where a party invokes the foreign decree as an integral aspect of his claim or defense. In Gerbert's case, since both the foreign divorce decree and the national law of the alien, recognizing his or her capacity to obtain a divorce, purport to be official acts of a sovereign authority, Section 24, Rule 132 of the Rules of Court comes into play. This section requires proof, either by 1. Official publications or 2. Copies attested by the officer having legal custody of the documents. If the copies of official records are not kept in the Philippines, these must be a. accompanied by a certificate issued by the proper diplomatic or consular officer in the Philippine Foreign Service stationed in the foreign country in which the record is kept, and b. authenticated by the seal of his office. The records show that Gerbert attached to his petition a copy of the divorce decree, as well as the required certificates proving its authenticity, but failed to include a copy of the Canadian law on divorce. Under this situation, we can, at this point, simply dismiss the petition for insufficiency of supporting evidence, unless we deem it more appropriate to remand the case to the RDC to determine whether the divorce decree is consistent with the Canadian divorce law. We deem it more appropriate to take this latter course of action, given the Article 26 interests that will be served and the Filipina wife's, Daisylyn's, obvious conformity with the petition. A remand, at the same time, will allow other interested parties to oppose the foreign judgment and overcome a petitioner's presumptive evidence of a right by proving want of jurisdiction, want of notice to a party, collusion, fraud, or clear mistake of law or fact. Needless to state, every precaution must be taken to ensure conformity with our laws before a recognition is made, as the foreign judgment, once recognized, shall have the effect of residential judicata between the parties as provided Indiana Section 48, Rule 39 of the Rules of Court. In fact, more than the principle of comity that is served by the practice of reciprocal recognition of foreign judgments between nations, the residential judicata effect of the foreign judgments of divorce serves as the deeper basis for extending judicial recognition and for considering the alien spouse bound by its terms. This same effect, as discussed above, will not obtain for the Filipino spouse were it not for the substantive rule that the second paragraph of Article 26 of the Family Code provides. Considerations beyond the recognition of the foreign divorce decree.